Senate will come back to order. Those not having privilege of the floor will please vacate the chambers. Senior Senator from the 5th.
Thank you, Mr. President. Request unanimous consent to go to the second order of business.
Is there objection? The chair hears none. Senior Senator from the 5th.
Thank you, Mr. President. On behalf of the body, I'd like to introduce a friend of mine that I went to college with at Marshall, and we spend a lot of time together vacationing, and he's a really great friend. He's come in for my brother's induction into the Hall of Fame, but if he would stand, Paul Dubé.
Are there further introductions? Bills on third reading.
Engrossed House Bill 4496, allowing interest and earnings on federal COVID-19 relief monies to be retained in the funds or accounts where those monies are invested. Third reading of the bill.
Question is on passage of the bill. Senior Senator from the 4th.
Thank you, Mr. President. This bill comes to us at the request of the executive and would permit all interest and earnings on federal COVID-19 relief monies to be retained in the funds or accounts where those monies are invested. Specifically, this would relate to monies received from the CARES and the American Rescue Plan Act. This bill would be retroactive in application to the date of receipt of the same federal monies. Mr. President, I urge passage of the bill.
Yes, sir. Senate will be at ease for one moment. Senate will come back to order. Senate will come back to order. Question is on passage of the bill. Is there discussion? If not, question for the Senate is, shall the bill pass? All those in favor will vote yea. Those opposed will vote nay. The clerk shall prepare the machine. Has every member voted? Has every member voted? If so, the clerk close the machine and ascertain the results. On this question, 34 yeas, 0 nays, 0 absent, not voting. More than a majority of those present and voting having voted in the affirmative, I declare the bill passed. The clerk will communicate the action of the Senate to the House.
Engrossed committee substitute for House Bill 4497, extending the regional jail per diem through July 1, 2023. Third reading of the bill.
Question is on passage of the bill. Senior Senator from the 4th.
Thank you, Mr. President. This bill would extend the per diem rate the counties and municipalities pay for regional jail costs per inmate per day at $48.25 for another year through July 1st, 2023. The bill likewise extends the reporting requirements in current law through 23. Mr. President, I urge passage of the bill.
Question is on passage of the bill. Is there discussion? If not, the question before the Senate is, shall the bill pass? All those in favor vote yea. Those opposed vote nay. The clerk should prepare the machine. Has every member voted? Has every member voted? If so, the clerk will close the machine and ascertain the results. On this question, 34 yeas, 0 nays, 0 absent, not voting. More than a majority of those present and voting having voted in the affirmative, I declare the bill passed. The clerk will communicate the action and send it to the House.
Engrossed committee substitute for House Bill 4511 to make numerous amendments to modernize and increase efficiencies in the administration of the West Virginia Unclaimed Property Act.
Question is on passage of the bill. Senior Senator from the 17th.
Thank you, Mr. President. Request unanimous consent for House Bill 4511 to move to third of bills on third read.
Is there objection? Chair hears none. So ordered.
Engrossed committee substitute for House Bill 4559, providing for legislative rulemaking relating to the disposition of unidentified and unclaimed remains in the possession of the Chief Medical Examiner. Third reading of the bill.
Question is on passage of the bill. Senior Senator from the 6th.
Thank you, Mr. President. House Bill 4559 authorizes the Office of the Chief Medical Examiner, CME, to make disposition of unidentified and unclaimed human remains. After exhausting efforts to contact a decedent's next of kin, unclaimed remains are to be cremated and placed in a cemetery where they may be retrieved easily should the next of kin wish to claim them. Unidentified remains are to be buried after 6 months, and all efforts to identify the remains have been unsuccessful. The Chief Medical Examiner is insulated from liability for actions consistent with the directives in the bill. The bill arose out of the November 2021 PERD report finding that the CME lacked authority to arrange for final disposition of decedent remains, and that, as a result, some remains had been stored in the CME's custody since the 1970s. I'll take questions, otherwise I urge passage of the bill, Mr. President.
Question is on passage of the bill. Is there discussion? If not, the question for the Senate is, shall the bill pass? All those in favor vote yea. Those opposed vote nay. The clerk should prepare the machine. Has every member voted? Has every member voted? If so, the clerk close the machine and ascertain the results on this question. 34 yeas, 0 nays, 0 absent, not voting. More than a majority of those present voting having voted in the affirmative, I declare the bill passed. The clerk will communicate the actions and send it to the House.
Engrossed committee substitute for House Bill 4563, third reading of the bill.
Question is on passage of the bill. Senator from Wetzel.
Thank you, Mr. President. This bill creates a new section in code authorizing temporary registration plates for auto mechanics. The auto mechanic temporary registration plate could be used by a mechanic to drive a vehicle that does not have a valid registration plate solely for the purpose of diagnosing vehicle problems. The bill permits auto mechanics to apply for access to the DMV electronic temporary plate issuance system. It gives the DMV the authority to terminate the system access if requirements of the bill are violated. Mechanics are required to provide the DMV with a certificate of insurance meeting West Virginia's minimum insurance requirements for any vehicle that displays the temporary plate while the vehicle is being operated. The bill specifies that the application and annual renewal fees for access to the DMV system and reference plate fees. The auto mechanic temporary plate fees would be in the same amount and format as those fees required of dealers participating in the electronic temporary plate issuance system. Each temporary plate would expire at the end of the day of issuance. The DMV testified that this bill would be revenue neutral. I urge passage of the bill.
Question is on passage of the bill. Is there discussion? If not, the question for the Senate is, shall the bill pass? All those in favor vote yea. Those opposed vote nay. The clerk should prepare the machine. Has every member voted? Has every member voted? If so, the clerk close the machine and ascertain the results on this question. 34 yeas, 0 nays, 0 absent, not voting. More than a majority of those present voting having voted in the affirmative, I declare the bill passed. The clerk has a title amendment.
Committee on Transportation and Infrastructure move to amend the title of the bill.
Question is on adoption of the title amendment. All those in favor say aye. Those opposed, no. The ayes appear to have it. The ayes do have it. I declare the title amendment adopted. The clerk will communicate the action and send it to the House.
Engrossed committee substitute for House Bill 4565 to exempt temporary employees and employees of the Higher Education Policy Commission from automatic enrollment into the state's 457B plan. Third reading of the bill.
Question is on passage of the bill. Senator from Jefferson.
Current law requires that every state employee commencing work on and after July 1, 2007 have a minimum of $10 per day period of his or her salary deferred to the state deferred compensation plan unless the state employee provides written notice declining to participate. This bill clarifies that temporary employees, employees of Higher Education Policy Commission, the Community and Technical College Council, and the state's public institutions of higher education are exempt from this requirement. The bill also strikes through language limiting the amount of a school employee's salary that can be deferred to the amount excludable from income under a 403B plan, since those employees can also participate in a 457 plan, which has separate limits. I urge passage.
Question is on passage of the bill. Is there discussion? If not, the question before the Senate is, shall the bill pass? All those in favor vote yea. Those opposed vote nay. The clerk shall prepare the machine. Has every member voted? Has every member voted? If so, the clerk close the machine and ascertain the results on this question. 34 yeas, 0 nays, 0 absent, not voting. More than a majority of those present voting having voted in the affirmative, I declare the bill passed. The clerk will communicate the action and send it to the House.
Engrossed House Bill 4566, creating the Economic Enhancement Grant Fund. Third reading of the bill.
Question is on passage of the bill. Senior Senator from the 4th.
Thank you, Mr. President. This bill would establish a new West Virginia Economic Enhancement Grant Fund to be administered by the Water Development Authority. This special program account shall be separate and distinct from any other money, fund, or funds owned and or managed by the Water Development Authority. These funds would generally be expended to provide the local or state match for any federal or other programs that require a match for projects and infrastructure projects in instances where the commitment of the matching funds is required to be made and submitted with an application for the federal or other grant. This bill also authorizes the WDA to enter into grant agreements subject to certain provisions. Lastly, the WDA must have an annual audit performed by an independent CPA with respect to this fund and all related subaccounts, with copies of the same provided to the Legislature. Mr. President, I urge passage of the bill.
Question is on passage of the bill. Is there discussion? If not, the question for the Senate is, shall the bill pass? All those in favor will vote yea. Those opposed will vote nay. The clerk shall prepare the machine. Has every member voted? Has every member voted? If so, the clerk close the machine and ascertain the results. On this question, 34 yeas, 0 nays, 0 absent, not voting. More than a majority of those present voting having voted in the affirmative, I declare the bill passed. Senior Senator from 17.
Thank you, Mr. President. Move the bill be made effective from passage. Request unanimous consent that the roll call used on passage of the bill be used to make it so effective.
Senior Senator from 17 moves the bill be made effective from passage and request unanimous consent that the roll call used on the passage of the bill be used to make it so effective. Is there objection? Chair hears none. On this question, 34 yeas, 0 nays, 0 absent, not voting. More than two-thirds of those elected to the Senate having voted in the affirmative, I declare the bill effective from passage. The clerk will communicate the actions and send it to the House.
Engrossed House Bill 4568 to allow phased rehabilitations of certified historic structures. Third reading of the bill.
Question is on passage of the bill. Senior Senator from the 4th.
Thank you, Mr. President. This bill would amend the provisions of the West Virginia Corporation Net Income Tax for Qualified Rehabilitated Buildings Investment, known as the Historic Tax Credit. Current law provides a credit against the corporate net income tax for qualified rehabilitation expenses on a certified historic structure in the amount of 25% of the total qualified rehabilitation expenses. The Division of Culture and History and the National Park Service determined the designation as a certified historic structure and the qualified rehabilitation expenses. The bill would eliminate current limits per project and per year credits. Current limit per project is $10 million total for the credits under both this section and the personal income tax credit authorized elsewhere in the code. Current limit per fiscal year is $30 million total for this credit and for the PIT credit. It also eliminates the reserve setback of credit for projects asking for credits of $500,000. It also authorizes credits for phased projects, which would allow the credit at the completion of a particular phase of the project, subject to clawback provisions if the project is not completed and certified within 60 months of the determination that a phase was complete. Mr. President, I urge passage of the bill.
Question is on passage of the bill. Is there discussion? Senior Senator from the 5th.
Request unanimous consent that on Rule 43 that I be excused from voting I am a president of the Keith Albee Performing Arts Center, which is in the Huntington Historic District, and could be eligible for these funds.
Is there objection? Chair hears none, so ordered. Senator from Marshall.
Thank you, Mr. President. I'd just like to quickly speak in favor of this bill. I've seen this bill within my district and also in towns close to my district, such as Wheeling, for instance, where this has been a huge tool for economic development. And without going into the details, it's just to be able to take this tax credit and piggyback it on the federal component as well. It's really stimulating some activity in my district and surrounding towns adjacent to my district. I would encourage passage.
Is there further discussion? If not, the question before the Senate is, shall the bill pass? All those in favor vote yea. Those opposed vote nay. The clerk shall prepare the machine. Has every member voted? Has every member voted? If so, the clerk close the machine and ascertain the results. On this question, 33 yeas, 0 nays, 0 absent, 1 excused. More than a majority of those present and voting having voted in the affirmative, I declare the bill passed. The clerk will communicate the action and send it to the House.
Engrossed committee substitute for House Bill 4608 to require the State Fire Commission to propose minimum standards for persons to be certified as probationary status volunteer firefighters. Third reading of the bill.
Question is on passage of the bill. Senior Senator from the 6th.
Thank you, Mr. President. House Bill 4608 requires the State Fire Commission to propose an emergency rule setting standards for individuals over age 18 to be certified as probationary volunteer firefighters. The bill is in response to a critical shortage of members, particularly younger members, in volunteer fire departments throughout the state. I'll take questions. Otherwise, I urge passage of the bill, Mr. President.
Question is on passage of the bill. Is there discussion? If not, the question before the Senate is, shall the bill pass? All those in favor vote yea. Those opposed vote nay. The clerk shall prepare them. So the clerk close the machine and ascertain the results. On this question, 34 yeas, 0 nays, 0 absent, not voting. More than a majority of those present and voting having voted in the affirmative, I declare the bill passed. The clerk will communicate the action and send it to the House.
Engrossed committee substitute for House Bill 4629 relating to procedures for certain actions against the state. Third reading of the bill.
Question is on passage of the bill. Senator from Morgan.
Thank you, Mr. President. House Bill 4629, as it was amended by the Senate yesterday, amends a section of code and adds a new section of code. Both of them are in Chapter 55, Article 17, which governs claims against the state. In the section amended, it amends a section that requires advance notice 30 days in writing to the Attorney General and the head of the agency before someone is able to file a suit or complaint against the state. This addresses that in the following manner. What it says is that if the suit is not filed, if the complaint's not filed within 90 days after the notice, then the person who wants to sue the state has to start that process over again and pay a fee. At the provide a new notice to the Attorney General and to the agency and pay a fee of $250 to each. There's a new section added to the bill which addresses the separation of powers, makes it clear that it is never permissible in a court in this state, no court in this state has authority to issue a writ of mandamus, prohibition, or injunction against the legislature. Makes it clear that it's impermissible for any person to name the presiding officers of the Senate or the House or the legislature in any suit challenging the constitutionality of a statute based on Article 5 of the Constitution, the separation of powers. It requires courts, when those things happen, to dismiss the case or dismiss the parties who are misjoined. The last subsection makes this retrospective, so it applies to any suits which are pending now in the state of West Virginia. Be happy to try to answer questions. I urge passage of the bill.
Question is on passage of the bill. Is there discussion? If not, the question for the Senate is, shall the bill pass? All those in favor will vote yea. Those opposed will vote nay. The clerk shall prepare the machine. Has every member voted? Has every member voted? If so, the clerk close the machine. Ascertain the results on this question. 34 yeas, 0 nays, 0 absent, not voting. More than a majority of those present voting having voted in the affirmative, I declare the bill passed. The clerk has the title amendment.
Committee on the Judiciary move to amend the title of the bill.
Question is on adoption of the title amendment. All those in favor say aye. Those opposed, no. The ayes appear to have it. The ayes do have it. I declare the title amendment adopted. The clerk will communicate the action and send it to the House.
Engrossed committee substitute for House Bill 4634 relating to occupational licensing or other authorization to practice.
Senior Senator from the 17th.
Thank you, Mr. President. Request unanimous consent that House Bill 4634 move to the foot of bills on third.
Is there objection? Chair hears none. So ordered.
Engrossed committee substitute for House Bill 4636 clarifying when business and occupation taxes owed to a city or municipality are considered to be remitted on time.
Senior Senator from the 17th.
Thank you, Mr. President. Request unanimous consent that 4636 move to the foot of bills on third.
Is there objection? Chair hears none. So ordered.
Engrossed committee substitute for House Bill 4662 relating to licensure of Head Start facilities in this state. Third reading of the bill. Okay, now they're saying that.
Senior Senator from the 17th.
Thank you, Mr. President. Request unanimous consent for 4662 to move to the foot of bills on third.
Is there objection? Chair hears none. So ordered.
Engrossed House Bill 4743 relating to security and surveillance requirements of medical cannabis organization facilities. Third reading of the bill.
Question is on passage of the bill. Senator from Marshall.
Thank you, Mr. President. This bill, Mr. President, adds language to the existing law regarding medical cannabis organization requirements to implement and maintain security, tracking, record-keeping, and surveillance systems related to medical cannabis. The proposed bill would add a proviso to the existing language that states the Bureau may require that a medical cannabis organization maintain motion-activated surveillance at a dispensary, grower, or processor facility, and that the medical cannabis organization retain the recordings therefrom on-site or off-site for a period not to exceed 180 days unless required for investigative or litigation purposes. Mr. President, this places our West Virginia law of 180 days in keeping with surrounding states. I urge passage.
Question is on passage of the bill. Is there discussion? If not, the question before the Senate is, shall the bill pass? All those in favor vote yea. Those opposed vote nay. The clerk shall prepare the... Has every member voted? Has every member voted? If so, the clerk close the machine and ascertain the results. On this question, 32 yeas, 2 nays, 0 absent, not voting. More than a majority of those present voting having voted in the affirmative, I declare the bill passed. The clerk will communicate the actions of the Senate to the House.
Engrossed committee substitute for House Bill 4787 creating the Highly Automated Motor Vehicle Act. Third reading of the bill.
Question is on passage of the bill. Senator from Morgan.
Thank you, Mr. President. House Bill 4787 would create a new article in the state code. It would go in, it'd be Article 17H, I think. Let me double check that. Yeah, 17, it's in Chapter 17H, and the article is designated 1. It's actually a new chapter in the code, and it has 15 new sections within it, all relating to highly automated motor vehicles, or as the article would be called, fully automated motor vehicles. Contains, as I said, 15 new sections. It covers fully autonomous motor vehicles, vehicles that don't have human drivers. It addresses the operation of those vehicles, fully autonomous vehicles. It addresses the operation of fully autonomous commercial and motor carrier vehicles. It addresses on-demand autonomous motor vehicle networks. It addresses a concept called platooning. Discusses duties following a crash. It addresses fully autonomous vehicles and whether or not they're exempt from state laws relating to ownership. It covers equipment standards, licensing, titling, and registration, insurance. Mr. President, I'll be happy to try to answer questions. I urge passage of the bill.
Then, question is on passage of the bill. Is there discussion? If not, question for the Senate, shall the bill pass? All those in favor vote yea. Those opposed will vote nay. The clerk will prepare the machine. Has every member voted? Has every member voted? If so, the clerk close the machine. Ascertain the results on this question. 34 yeas, 0 nays, 0 absent, not voting. More than a majority of those present voting having voted in the affirmative, I declare the bill passed. The clerk has the title amendment.
Committee on the Judiciary moved to amend the title of the bill.
Question is on adoption of the title amendment. All those in favor will say aye. Aye. Those opposed, no. The ayes appear to have it. The ayes do have it. I declare the title amendment adopted. The clerk will communicate the action and send it to the House.
Engrossed committee substitute for House Bill 4826 relating to esports. Third reading of the bill.
Question is on passage of the bill. Senator from Morgan.
Thank you, Mr. President. House Bill 4826 amends West Virginia's Sports Wagering Lottery Act, or the West Virginia Lottery Sports Wagering Act. It would amend a single section in the Act to cover wagering supervised, regulated by the Lottery Commission upon the outcome of video games. Mr. President, I'd be happy to try to answer questions. I urge passage of the bill.
Question is on passage of the bill. Is there discussion? If not, the question for the Senate is, shall the bill pass? All those in favor vote yea. Those opposed will vote nay. The clerk will prepare the machine. Has every member voted? Has every member voted? If so, the clerk will close the machine. Ascertain the results on this question. 27 yeas, 7 nays, 0 absent, not voting. More than a majority of those present and voting having voted in the affirmative, I declare the bill passed. The clerk will communicate the action and send it to the House.
Engrossed House Bill 4829 modifying definitions of certain school cafeteria personnel.
Senior Senator from the 17th.
Thank you, Mr. President. Request unanimous consent that House Bill 4829 move to the third of bills on third.
Is there objection? Chair hears none. So ordered.
Engrossed House Bill 4848 relating to non-intoxicating beer, wine, and liquor licenses. Third reading of the bill. The bill is advanced to third reading with the right to amend.
Are there amendments to the bill?
Yes, sir. The Committee on the Judiciary moved to amend the bill by striking out everything after the enacting clause.
Senator from Morgan.
Thank you, Mr. President. I request unanimous consent to explain the committee amendment in lieu of having it read.
Is there objection? Chair hears none. Senator from Morgan.
Thank you, Mr. President. The committee amendment is a strike and insert amendment for the entire bill. The committee amendment is very similar to a Senate bill which we passed and is in the possession of the House of Delegates right now, but it contains all the same provisions that were in our original Senate bill, although some of them are modified slightly. And this, with the committee amendment, has adopted a number of changes that were in the House bill. Let me go over them if I may. First of all, the amendments are to various sections in Chapter 60 of the Code, which is Alcohol Chapter, Chapter 11, which Chapter 11 is taxation largely, but contains most of the statutes that relate to beer are Chapter 11. Anyway, the bill would amend the law regarding some aspects of our regulation of non-intoxicating beer, wine, cider, and liquors. The bill clarifies that licensees, are not required to bag the product when they sell it for off-premises consumption. So that would be a grocery store, a convenience store. The bill modifies the 300-foot rule, precluding a licensee from opening or being within 300 feet of a church or school, changes that to 200 feet, and has a further provision in it that says if the school, college, or church waives in writing the location, agrees in writing, then the 200-foot restriction would not apply. That's up to the church or school or college. The bill updates the code regarding the posting of blood alcohol charts. It increases the minimum markup, and we went back and forth on this on both bills a couple times in committee, but as the bill lies on the floor before us now, the House bill with the committee amendment adopted, there's no markup. The mandatory minimum markup for sales to individuals is unchanged. It's 10%, but for sales to retailers, from retailers to private clubs, restaurants, the minimum markup would be 112.5%, 12.5%. The bill creates a number of new licenses that can be issued by the ABC Commission. There's a private bakery license, a private cigar shop license, a private food truck license, a private college sports stadium or coliseum license. There are updated provisions with respect to mini bars and hotels. The bill establishes fees for the new licenses, and it allows certain licensees to cater off-premises events, so weddings, that sort of thing. The bill allows wine growlers. It updates provisions relating to minors. It increases the cap on delivery fees from $5 to $20. Now, that was not something that was in our original Senate bill that we sent to the House. But our law has a cap on a delivery fee of $5. This bill would increase that cap to $20. The bill removes provisions requiring delivery people to permanently maintain information regarding to whom a delivery is made. And the bill now contains yet another bill that we passed previously relating to Russian vodka, requiring its sale and precluding, codifying the governor's executive order that the state warehouse can no longer buy vodka from Russia, and requiring that what's there to be sold with the proceeds to be provided to an organization that will benefit the citizens of Ukraine. Mr. President, I'll be happy to try to answer questions. I urge passage of the bill.
Clerk has an amendment to the amendment.
Senator Trump moved to amend the amendment on page 70.
Senator from Morgan.
Senator Trump moved to amend the amendment on page 70, section 6F, line 42, after the word dollars by adding the following. The convenience fee charged by the third-party private wine delivery licensee to the purchasing person shall be no greater than $20 per delivery order when wine is ordered by the purchasing person. For any third-party licensee also licensed for non-intoxicating beer or non-intoxicating craft beer, delivery is set forth in 1116-6F of the code. The total convenience fee of any order, sale, and delivery shall not exceed $20.
Is there discussion? Senator from Oregon.
Mr. President, that amendment is technical and corrects the wording that's in the committee amendment.
Is there further discussion? If not, the question for the Senate is adoption of the amendment to the amendment offered by the senator from Oregon. All those in favor say aye. Aye. Those opposed, no. The ayes appear to have it. The ayes do have it. I declare the amendment to the amendment adopted. Are there further amendments to the amendment?
No, sir.
Is there discussion on the Judiciary Committee amendment as amended? If not, the question for the Senate is adoption of the amendment offered by the Committee on the Judiciary as amended. All those in favor say aye. Those opposed, no. The ayes appear to have it. The ayes do have it. I declare the amendment adopted. Are there further amendments to the bill?
No, sir.
Question is on passes the bill. Is there discussion? Senior Senator from the 4th.
You have a worried look on your face there, Mr. President. There's a part of this bill that I really like, and that's about selling the Russian vodka and donating the proceeds to those in the Ukraine. And there's a current effort going on actually by the general here for our National Guard here in West Virginia to send body armor to the citizens of Ukraine. And so if you're looking for a worthy cause for those that are selling this Russian vodka to send something to, we can send body armor to citizens of Ukraine. You just got to reach out to our adjunct general. I urge support of the bill.
Is there further discussion? If not, the question before the Senate is shall the bill pass. All those in favor will vote yea. Those opposed vote nay. The clerk should prepare them. Has Senator from Wyoming? Senator from Wyoming? Has every member voted? Has every member voted? If so, the clerk close the machine and ascertain the results. On this question, 26 yeas, 8 nays, 0 absent, not voting. More than a majority of those present and voting having voted in the affirmative, I declare the bill passed. Clerk has a time moment.
Committee on the Judiciary moved to amend the title of the bill.
Senator from Oregon.
Thank you, Mr. President, I request unanimous consent to withdraw the committee title amendment.
Is there objection? Chair hears none. So ordered. The clerk has another title amendment.
Senator Trump moved to amend the title of the bill.
Question is discussion. Senator from Oregon.
Thank you, Mr. President. This is a much better title for the bill. I urge its adoption.
Question is on adoption of the title amendment. Roll call has been demand sustained. The demand is not sustained. All those in favor will say aye. Aye. Those opposed, no. The ayes appear to have it. The ayes do have it. I declare the title amendment adopted. The clerk will communicate the action of the Senate to the House. Senior Senator from the 17th.
Thank you, Mr. President. Request unanimous consent to move to the 9th order of business.
Is there objection? Chair hears none. So ordered. Bills on second reading. Senior Senator from the 17th.
Thank you, Mr. President. Request unanimous consent that all bills on second reading be considered read a second time and advanced to third reading with right to amend.
Is there objection? Chair hears none. So ordered. Senior Senator from the 17th. Clerk needs to read the bill.
Engrossed House Joint Resolution 104, providing term limits for certain constitutional officers. Second reading of the resolution.
Senior Senator from the 17th.
Thank you, Mr. President. Request unanimous consent that HDR 104 be moved to third with right to amend.
Is there objection? Chair hears none. So ordered. Senator will be at ease for just a few moments.
For third offense felony.
Are there objections to having the bill explained in lieu of having it read? If not, gentleman number 35th, Doug Capito, to explain the bill. Gentleman number 32nd, Doug Fast, to explain the bill.
Thank you, Mr. Chairman. Senate Bill 232 relates to punishment for third offense felony. The bill amends a section of code relating to punishment of repeat felony offenders. It clarifies that a prior conviction which resulted in imprisonment in a federal correctional facility shall be considered for purposes of enhanced sentencing. It clarifies that the prior charge includes the most recent previous qualifying offense. And it also adds a provision that the most previous qualifying offense may not be considered if more than 20 years have elapsed between, number one, the release of the person from the term of imprisonment or period of supervision resulting from that offense, and number two, the conduct underlying the current charge. Just by way of an example, if a person was convicted in 2000 and then released in 2010, if that person was again convicted on an incident that occurred in 2022, the 2000 conviction would count because there would have only been 12 years between the release date on the earlier conviction and the incident of the second conviction. Currently, the 20 years starts to run from the first conviction. Under this bill, the 20 years would start to run from the date of release. That is a summary, Mr. Speaker. I urge passage.
The question before the House is, shall the bill pass? Is there debate on the bill? Lady in the 51st, Doug Fleshauer is recognized.
Thank you, Mr. Speaker. Will the gentleman yield?
Yes.
So how many years before you would get enhanced sentencing?
20 years from the date of the prior release, as opposed to 20 years from the date of the prior conviction.
Oh, okay.
That's the change in the
So
bill.
if you served your time, you would get an additional penalty if you were serving time again.
Well,
But
if within
unless
that
20 years had elapsed. Okay.
If the incident on the second matter occurred within 20 years of the release on the first matter, yes.
And does the second need to be a felony?
Yes. That's a qualifying offense, yes.
Okay, thank you.
Question again is, shall the bill pass? Is there debate on the bill? Gentleman 37, Doug Pushkin is recognized.
Thank you, Mr. Speaker. Will gentleman continue to yield?
Yes.
Thanks. I don't want you to go through all the qualifying offenses, but are some of them, could they be considered nonviolent offenses?
The list on pages 1 and 2 of the bill, these are violent offenses. It is intended to be for violent offenses.
So this is only limited to violent offenders?
That is my understanding.
Okay, thank you.
Yes, sir.
Question again is, shall the bill pass? Is there debate on the bill? If not, those in favor of passage of the bill will vote aye. Those opposed will vote no. The clerk will prepare the machine. Has every member voted? If so, the clerk will close the machine and ascertain the result. On this question, there are 86 ayes, 5 nays, 9 members absent. A majority of members voting in the affirmative. The chair declares that bill passed. The clerk will please report the title.
Committee substitute for Senate Bill 232 relating to punishment for third offense felony.
Are there amendments to the title? If not, the title as read by the clerk will be and remain the title of the bill. The clerk will please communicate the action of the House to the Senate. Next bill on third reading.
Committee substitute for Senate Bill 242 restricting authority to prevent or limit owners' use of natural resources or real property in certain agricultural operations.
Are there objections to having the bill explained in lieu of having it read? If not, the gentleman 35th, Dr. Capito, to explain the bill.
Thank you, Mr. Speaker. Current law provides that an ordinance, rule, or regulation may not prevent a landowner's complete use of natural resources outside of urban areas. The amendment would expand this to include an ordinance, rule, or regulation preventing or limiting an owner's complete use of natural resources outside municipalities or urban areas, or an owner's complete use of a tract or contiguous tracts of land of any size for a farm or agricultural operation outside of municipalities or urban areas. The bill also refers to the definition of agritourism. Mr. Speaker, that's a summarization of the bill. I urge passage.
Question before the House is, shall the bill pass? Is there debate on the bill? If not, those in favor of passage of the bill will vote aye. Those opposed will vote no. The clerk will prepare the machine. Has every member voted? If so, the clerk will close the machine and ascertain the result on that question. There are 89 ayes, 4 nays, and 7 members absent. A majority of members voting in the affirmative. The chair declares that bill passed. The clerk will please report the title.
Committee substitute for Senate Bill 242 restricting authority to prevent or limit owners' use of natural resources or real property in certain agricultural operations.
Are there amendments to the title? If not, the title as read by the clerk will be and remain the title of the bill. The clerk will please communicate the action of the House to the Senate. Next bill on third reading.
Committee substitute for Senate Bill 246 requiring newly constructed public schools and public schools with major improvements to have water bottle filling stations.
Question is, shall the bill pass? Is there debate on the bill? Are there objections to having the bill explained in lieu of having it read? If not, Lady 38th, Dr. Graves, to explain the bill.
I feel like the clerk did a great job explaining it already, but I'll just say this bill requires the State Board of Ed to promulgate 2 new rules. The first rule is just to require that newly constructed public school buildings include water bottle filling stations. And the second rule is that existing public school buildings undergoing major improvement also offer water bottle filling stations. It's for healthier students. I urge passage.
Question before the House, shall the bill pass? Is there debate on this bill? If not, those in favor of passage of the bill will vote aye. Those opposed will vote no. The clerk will prepare the machine. Has every member voted? If so, the clerk will close the machine and ascertain the result on that question. There were 83 ayes, 10 nays, and 7 members absent. A majority of members voting in the affirmative. The chair declares that bill passed. The clerk will please report the title.
Committee substitute for Senate Bill 246, requiring newly constructed public schools and public schools with major improvements to have water bottle filling stations.
Are there amendments to the title?
Delegate Ellington moves to amend the title.
Question is on the adoption of the title amendment. Those in favor of adoption of the title amendment will please say aye. Those opposed will please say no. The ayes have it. The chair declares the title amendment adopted. The title as amended by the House will be and remain the title of the bill. The clerk will please communicate the action of the House to the Senate. Next bill on third reading.
Committee substitute for Senate Bill 262, relating generally to financial institutions engaged in boycotts of energy companies.
Are there objections to having the bill explained in lieu of having it read? If not, the gentleman from the 16th, Doug Linville, to explain the bill.
Thank you, Mr. Speaker. Committee substitute for Senate Bill 262 relates generally to financial institutions which are engaged in boycotts of energy companies. For the benefit of the body, we did adopt a fairly comprehensive amendment yesterday. This bill would amend the provisions of West Virginia Code by adding new provisions relating to financial institutions engaged in the boycott of energy companies. The bill defines a boycott of energy companies as without an ordinary business purpose, though again we adopted an amendment which replaced that language with reasonable business purpose as defined, which would include promoting the financial success or stability of a financial institution, mitigating risk to a financial institution, limiting liability of a financial institution, which is already in the bill. So they would be engaging in things other than that. The bill defines that, then goes on to say that the entities which are in play here are those which engage in the exploration, production, utilization, transportation, sale, or manufacturing of fossil fuel-based energy, and does not commit or pledge to meet environmental standards beyond applicable federal and state law, or 3, does business with a company that engages in those activities. The bill would authorize the Treasurer to prepare and maintain a list of financial institutions that are engaged in a boycott of energy companies, known as the Restricted Financial Institution List. Once that list is created, the Treasurer would be required to publicly post the list on the Treasurer's website and submit a copy to the Governor, the President of the Senate, and the Speaker of the House. The Treasurer must update this list at least annually. When an entity is placed on the list, the Treasurer would be required to provide written notice to the entity and that it may be ineligible to enter into or remain in banking contracts with the state. Though again, the amendment adopted yesterday further defines and allows for a period of time for the entity to protest. The entity may provide information to the Treasurer demonstrating that it is not so engaged in a boycott, or that it has ceased activities that boycott energy companies. If the Treasurer is satisfied with this information, the Treasurer must remove the entity from the list. The Treasurer would be authorized to disqualify a restricted financial institution from competitive bidding processes or other selection process, to refuse to enter into a banking contract with a restricted financial institution, and to require as a term of any banking contract an agreement not to engage in a boycott for the duration of the contract. The bill provides immunity from liability for actions taken in compliance with the new provisions. In addition, the new provisions do not apply to the duties, actions, and transactions of the West Virginia Investment Management Board. To summarize, I've mentioned some of these modifications we made yesterday. It also provides more guidance on what sources of information that the Treasurer must consider and may rely upon in making the determination, and it provides that an institution may not be compelled to provide or disclose information deemed confidential, privileged, or otherwise protected from disclosure by state or federal law. That is the bill, Mr. Speaker. I'm happy to take any questions, and I do urge passage.
Question for the House is, shall the bill pass? Gentleman first, Doug Teselo.
Thank you, Mr. Speaker. Well, this is one bill that I definitely planned on speaking to today. You know, there's a fellow who runs BlackRock Financial. His name's Larry Fink. I think he's pretty aptly named, to tell you the truth. He's embraced the new Green Deal woke agenda. And he's one of the prime leaders in cutting off funding for fossil fuels. To our credit, our treasurer, Riley Moore, has led the charge against this type of banking by, I don't even know what to call it. We in this country, and I think you can see it right now, are suffering through the terrible inflation due to prices of gasoline, energy, electricity, and other things. And part of it is a contrived crisis where you're not allowed to invest in fossil fuels. This is premature. If you want to have renewables, you're going to need an awful lot of rare earth elements. You're going to have them for cars, you're going to have them for batteries and other things. Where are we going to get these rare earth minerals and start this big move to renewables? I submit to you, it's a long way off. It is premature to do this. You do not stop investing in fossil fuels before you have everything in place. It is going to be at least 10 years before this happens, I can tell you right now. We need to make a statement, and all the energy-producing states in the United States of America need to make a statement. We are doing it in behalf of the American people. We don't deserve to have our economy wrecked when, for instance, 72% of the coal-fired generating capacity is in Asia, and we have 6%. It's nonsense. The whole thing is nonsense. China's going to increase their production next year. They're going to put in $3 billion coal mines. We have nothing to apologize for. We're trying to take steps to broaden our energy base, and we should do it when we choose to do it. And banks in this country, it's almost sedition that they would not allow investment in fossil fuels while sending their money over to China, which basically is increasing its coal-fired power generation by at least 10% a year. So, Mr. Speaker, I firmly and absolutely, we have to pass this bill, and we have to give the Treasurer the aid that he needs, and hopefully other states will join in and we can make a statement. Otherwise, $10 gas isn't too far off. Thank you.
Gentleman 36, second row, is recognized.
Thank you. Would the gentleman from who introduced the bill answer some questions? I recollect from the Finance Committee meeting that the Treasurer was asked very directly that what this is about is companies that are boycotting fossil fuels. It is not, and he would not put on, and I think he testified that he would not put on the list any sort of financial institution that invested only in green energy sources, and that was a part of their mission.
That is correct.
All right. Thank you, sir.
Gentleman 16, taking Hornbuckle.
Thank you, Mr. Speaker. Would the gentleman yield?
Yes.
And so as this legislation reads, it would prevent anyone in the state as a financial institution from doing business with someone such as BlackRock?
I don't think it particularly lists BlackRock, but I believe that would meet the
example.
For example, certainly.
Okay. May I have permission to speak to the bill?
Yes, the gentleman is recognized.
Thank you, Mr. Speaker. Colleagues, I think this is a very dangerous proposition, and I don't know if all the facts are being told today. I would tell you that having experience in this industry, being a financial advisor, you always want to make sure that you have a diversified portfolio. BlackRock is actually the world's leading asset manager. And I would like to share with you all today, to clear up some things on this House floor, that investment manager who holds about $10 trillion in client funds, he wanted to speak to this. He was actually responding to the state of Texas when they were pushing this measure. So much so that he says just right here, dear to whom it may concern, we will continue to invest in and support fossil fuel companies, including Texas fossil fuel companies. And I want you all to see here, we are perhaps the world's largest investor in fossil fuel companies, and as a long-term investor in these companies, we want to see these companies succeed and prosper. I think this is a knee-jerk reaction. I think we need to slow down, take a pause, because this company could be something in the toolkit to help a lot of the programs that we have in West Virginia to keep going forward. And I very much understand the sentiment of not wanting to do business with someone who is disparaging some that has been the backbone of our state. But we need to make sure we have the facts straight, and they also are not completely getting out of fossil fuels, and they would like to continue to support those. So I think that we should vote this down. Thank you.
Gentleman to 16th, Doug Linwood, close debate on the bill.
Thank you, Mr. Speaker. A few items. I'd like to first quote from the environmental and social governance policies of J.P. Morgan Chase. J.P. Morgan Chase. On coal, this is on page 4 of their environmental and social policy framework. On coal, prohibition on development of Greenfield coal mines. J.P. Morgan Chase will not provide project financing or other forms of asset-specific financing where the proceeds will be used to develop a new Greenfield coal mine. Prohibition on financing for coal mining clients. J.P. Morgan Chase will not provide lending, capital markets, or advisory services to clients deriving the majority of their revenues from the extraction of coal. By the end of 2024, we will also phase out our remaining credit exposure to such clients. Prohibition on financing to clients involved in mountaintop mining. Oh, here's one. Coal-fired power generation. Prohibition on financing of new coal-fired power plants. J.P. Morgan Chase will not provide project financing or other forms of asset-specific financing where the proceeds will be used to develop a new coal-fired power plant or refinance an existing coal-fired power plant. Coal-fired power plants utilizing carbon capture and sequestration technology will be considered only on a case-by-case basis. They go into enhanced review if anyone's involved in a business deal with those sorts of entities. There's been a lot of discussion about this bill, but I want to say really quick, we're not regulating or harming a company's free speech. They can continue to do that. They can choose who they wish to do business with or not. We are a market participant. Where we place our tax dollars, 80 million last month of which were derived from coal, where we choose to place our tax dollars is our decision. We won't regulate them out of the market. They can do whatever they wish. It's not going to be unlawful for anyone to do these sorts of things. So while my colleague from the 16th, brought up BlackRock, this is not specific to BlackRock. And of course, BlackRock changed their position under pressure from Texas. So if I may, I'd like to point out that our state's treasurer, Riley Moore, has led on this issue, has led a coalition on this issue. And at the current time, in other countries, in the European Union, if you look at what Russia is doing right now, the sanctions on Russia are less effective because Europe is having to buy their coal from Russia. There are United States banks who are trying to harm our coal industry when coal is $450 a ton for steam coal on the spot price in Europe right now. We're having trouble getting it there on the railroads, for goodness sakes, right now. The state of West Virginia just last month likely lost more than $15 million because we couldn't get our coal to market. Put our people to work, and for God's sake, don't put our tax dollars to use in banks that want to harm our economies and harm our miners and harm our coal operators and harm this state's general revenue fund and every last dime that we've been trying to appropriate for all the programs everybody loves. Please pass the bill.
Question before the House is, shall the bill pass? Those in favor of passage of the bill will vote aye. Those opposed will vote no. The clerk will prepare the machine. Has every member voted? If so, the clerk will close the machine and ascertain the result. On that question, there were 80 ayes, 14 nays, and 6 members absent. Majority of members voting in the affirmative. The chair declares that bill passed. The clerk will please report the title.
Committee substitute for Senate Bill 262, relating generally to financial institutions engaged in boycotts of energy companies.
Are there amendments to the title?
The Committee on Finance moves to amend the title.
Question is the adoption of the title amendment. Those in favor of adoption of the title amendment will please say aye. Those opposed will please say no. The ayes have it. Chair declares the title amendment adopted. The title as amended by the House will be and remain the title of the bill. The clerk will please communicate the action of the House to the Senate. Next bill on third reading.
Committee substitute for Senate Bill 264, relating to Conservation Districts Law of West Virginia.
The question before the House is, shall the bill pass? Are there objections to having the bill explained in lieu of having it read? No objections are heard. Gentleman from the 29th delegate Steele to explain the bill.
Thank you, Mr. Speaker. The purpose of this bill is to restructure the manner by which conservation district supervisors are elected and to modernize the qualifications for the position. The bill is a result of a years-long discussion among conservation district supervisors on what can be done to improve the delivery of conservation services and expand the pool of eligible persons who can run for the office. That is the bill, Mr. Speaker, and I urge passage.
The question before the House is, shall the bill pass? Is there debate on the bill? Gentleman from the 10th delegate Chris.
Will Chairman yield?
Yes.
Yeah, in the modernization of the qualifications, are we still going to be able to keep people that are in the farming industry on this conservation?
There's still going to be people in the farming industry is going to be the primary focus. I know that the definition was expanded slightly, and I'm trying to get to the place in the bill where that was expanded at, but I know forestry got added into it. Natural resources, experience, agriculture, conservation, and the definition of agriculture was expanded largely to, yeah, there it is. Harvesting of silviculture products, which would be the forestry, packing, shipping, milling, marketing agricultural products. So someone that may not be an actual farmer, but it deals in farm products, maybe a seller of farm products would be included. So what we're hoping with that expansion of the definition of agriculture, you have people that are ancillary to the agriculture industry that may not be farmers themselves, but certainly would add value and depth to, and it's very difficult. Me and you both know the large number of these posts that no one even seeks the office. So.
Yeah, and that's true, and we have an older population that are getting to the point where they can't come to the meetings and do the experience things that we need them to do. So, but I need to make sure that that we still have a farming intent on these boards so that we don't lose that touch.
Probably the widest expansion would be to include harvesting of silviculture or forestry. Okay. Most everything else was ancillary to the actual business of farming itself.
All right, sir. Thank you very much.
Thank you.
Is there debate on the bill? If not, does the gentleman wish to close debate on the bill? If not, those in favor of the question before the House is, shall the bill pass? Those in favor of passage of the bill will vote aye. Those opposed will vote no. The clerk will prepare the machine. Has every member voted? If so, the clerk will close the machine and ascertain the result on that question. There are 95 ayes, 0 nays, and 5 members absent. A majority of members voting in the affirmative. The chair declares that bill passed. The clerk will please report the title.
Committee substitute for Senate Bill 264 relating to Conservation Districts Law of West Virginia.
Are there amendments to the title? Are there amendments to the title? If not, the title as read by the clerk will be and remain the title of the bill. The clerk will please communicate the action of the House to the Senate. Next bill on third reading.
Committee substitute for Senate Bill 268 creating exemption from compulsory school attendance for child who participates in Learning Pod or micro school.
Are there objections to having this bill explained in lieu of having it read? If not, gentleman from the 27th, Delegate Ellington, to explain the bill.
Thank you, Mr. Speaker. The committee substitute for this bill creates a new compulsory school attendance exemption for children who participate in a learning pod or a micro school. The bill sets forth the following definitions. A learning pod means a voluntary association of parents choosing to group their children together to participate in their elementary or secondary academic studies as an alternative to enrolling in a public school, private school, home school, or micro school, including participation in an activity or service that is provided to the children. A micro school means a school that is initiated by one or more teachers or an entity that is created to operate a school as an alternative to enrolling in a public school, private school, homeschool, or a learning pod. The bill mirrors the following provisions regarding homeschool instruction and applies them to learning pods and microschools. 1, it requires the filing of a notice of intent with the county superintendent. 2, establishes the education-related qualifications for the person that is providing instruction, either a high school diploma or post-secondary or a secondary higher education degree such as a bachelor's. It requires an annual academic assessment of the child in one of 4 specified ways, whether it be through a standardized test, exam. It's already implemented in the West Virginia public school system, portfolio, or an alternative method approved by the county superintendent. It also requires copies of each student's academic assessment be maintained for 3 years. It establishes requirements applicable when the annual assessment fails to show any acceptable progress. It requires the county board, upon request, to notify the parents or legal guardian of services that are available to assist in the assessment of the child's eligibility for special education services. It requires submission of the results of the academic assessment. It requires county superintendent or designee to offer assistance, including textbooks or other teaching materials that are available, all subject to availability. It also allows the learning pod or microschool student to attend any class offered by a county board upon approval by the county board. The bill provides that learning pods and microschools are not subject to any other provision of law relating to education, provided that any learning pod or microschool which has a student requiring special education instruction must comply with the provisions of Section 18-2011 of the Code, including the placement of video cameras for the protection of that exceptional student. The bill further states that making learning pods and microschools subject to the home instruction provisions does not make those learning pods or microschools the same as homeschooling. Mr. Speaker, that is the bill. I'll be glad to answer questions, and I urge passage.
Question before the House is, shall the bill pass? Is there debate on the bill? The gentleman from the 39th, Douglas Farrell, is recognized.
Yes, thank you, Mr. Speaker. And I rise today in serious concern about this bill, and especially one particular part of it. And let me say first that there's a component part of it that deals with homeschools and the pods and things that I have absolutely no problem with. I think we should be trying to help. I mean, we saw some of the passion of the people involved in homeschooling here yesterday, and when you see that kind of passion, I think, toward educational learning, that's a good thing. We should encourage that, and we should be trying to help them. And I think some of these pods could possibly do that, you know, if we look at it. But I think of a pod, I think of half a dozen kids, I think of maybe a dozen kids or something in there, and working with your neighbors or maybe some extended family and so forth and friends to put together a learning pod and do that. So those are good things. I'm also not concerned about the freedom of people to be able to choose what type of education they want their children to have. I think that's a good thing. I think we all should encourage that. So those are not issues with this bill, but where it, to me, takes a sinister turn is when we get into these micro schools, micro school. And use the term micro, I think micro, but it goes to the original bill, had a cap of up to 100, which we tried to put back on yesterday, I think. But you look, there's 100 members in this delegation. I don't think there's anything micro about this delegation. So that's concerning right out of the gate. And so, you know, you got a school going on. Once you get up in those kind of numbers, and then we had an amendment that removed the 100. So now anybody can come in and open up a school, give notice to the Board of Education. They don't have to have permission. They just give notice to the Board of Education. They're going to open this school and start enrolling kids in. Make notice of the kids that are enrolling there, but they can take as many kids as they want and charge to do it. And so 100 kids, and I want to charge $5,000 per pupil to come into my school, and I guess I could do it in the garage or wherever, because again, there's no stipulation about the facility or the safety of the facility. I can just stick it anywhere and charge tuition, or I could even charge for a particular skill or a particular project that I'm offering in there, I could charge extra to the students to do. But even 100 kids, that's $500,000. That's $500,000 that somebody with 100 students can just put together, and then maybe run it 2 or 3 weeks, and then boom, they're out of town. And don't tell me it hasn't happened. We had it happen right here in Kanawha Valley. We've had a situation where somebody tried to start a prep school for sports, and that went south real fast. It was bad. And money was taken, not recovered, and we were looking at jail times and things. So, when you look at this, the concerns for these micro schools, there's no background checks of who's going to start one, where they're from, what type of criminal history they may or may not have, facility safety, as I said, ADA requirements. Are they going to make these available to every kid? Not sure about it. It doesn't say. Nutrition, it's not addressed. Financials, that we just talked about. There's no accountability for the financials of this situation. And we're talking about people's money. So, all that, there's no limit on the number of schools. I mean, if I had a charter school and I'm trying to play by the rules, where I've got a Catholic school or a Christian school or Cross Lanes Christian or whomever, I've got to be concerned about this. I've got to be, because I'm out trying to do the right thing and have parameters and boundaries and those kinds of things, and this just gives a license for people to do what they want to do. So I see red flags all over the place, and it takes me back. I was thinking yesterday to the old nursery rhyme of Little Red Riding Hood, and we all know how the wolf went in and took Grandma, trying to disguise it and disguise to look like Grandma, and Little Red Riding Hood goes, "My, what big ears you have, what a big nose you have, and finally, what teeth you have." And when we start looking at this bill, and you start asking these kind of questions, you start getting some really serious reservations about what's going on here. When you start seeing that many red flags come up, I think we've got a problem. And it's really, really unfortunate that this thing, this micro school thing, has attached itself to something that could be a good bill, but it's done it. And we see that all the time in life, where something good attaches itself, something sinister attaches itself to something good as a parasite and ruins the whole thing. So we have that going on, and so our job, we look at here, I think, as legislature and delegates, is to look out for I think our number one goal is to look out for the safety and well-being of the citizens that we serve. And I know that in education, in my career, my number one goal was to look out for the safety and well-being of the students that I was in charge of. Just yesterday, we passed a bill out of here, I think SB 261, and that was for the cameras in the classrooms, special ed classrooms. What was that bill about? It was oversight. It was extra layer of oversight and safety to try to look out for the interest and well-being of those special needs students that need our help to do that. Their parents couldn't do it on their own. We had to do that here from the state legislature, so that's our job to do that. And we voted it out 100-0, I believe. It was unanimous. We took it out of here. Everybody agreed we need to look out for the safety and well-being, especially those kids that are less fortunate. This week we had some kids that were less fortunate down front. Some of us got some pictures with them. It was great. They had parents here that could advocate for them. But for every couple like that were here that had parents that could advocate for them, let me tell you, I've done this for most of my career, most of my life. Most of those kinds of kids don't have somebody to advocate for them. They don't. We're it. We have to look out for the interest and well-being. Let me tell you, the first of this year, I go back in. I thought I'd retired. They called me back in over at South Charleston High School because of the teacher shortage. I'm in the classroom, and I get a couple of girls. They called me in the office, and there was a couple of girls that checked in, come in from Huntington High School, special needs girls, MI. Their mother was with them. She walked down to the classroom. We got them settled in. She spent half the morning there trying to get them affiliated with the new classroom, new kids, new environment. But these kids really struggle. These kids really struggle with change and with differences. And she left right before lunch. I spent the rest of the afternoon with one of the sisters. This is an 11th grader in tears crying for her mommy. Now, you think about that. These kids, they're relying upon us to look out for them. And we have this girl crying in the classroom like a first grader, Mr. Mom, first day of school. And we finally go through and we get her acclimated and we get her, and the days go by and we get her, and she gets comfortable. She gets comfortable with me as her teacher.
and with other classmates in there and stuff. So we go on and it gets to be Thanksgiving break, and we break and we go out for the week, and we come back and Hannah and Elizabeth aren't there. We ask what happened. We find out Mom's in the hospital with COVID. A couple days later, Mom's dead from COVID. And so we've got these two young ladies here who are scared. They don't know. They're just innocent. And so we're trying to figure out, and then before they can come back, I have to leave and come up here. And I've had them text and send a message, because they can do that. They know how to do electronics, but want to know where Mr. Farrell was. I'm sorry, girls. I'm up here. I have to go to somewhere different. But Miss Waller, she's a great teacher. She'll take care of you. But they're trusting me to watch out for them. Or trust, I think, for less ones like that to look out for them. And as it goes for every kid in our schools, to do the best thing in the best interest. And so when we see something like this, and this is a bill that struggled even in committee. It got out, I think, 11-8, and that was with several members that had different obligations, couldn't be there. There were several reservations about even voting yes on it there. It comes down here yesterday, and we had an amendment to try to get the 100 cap back in, and that was narrowly defeated, I think a couple of votes. So I know people here have reservations about this. This thing is scary, and rightfully so. And I think, like I said, our job is to look out. So rather than rush into this, I'm looking at, let's stop. We can write another bill that takes care of the homeschoolers with the pods built in there and that system set up. And let's separate this micro school thing. Let's take some time. Let's do a study on it this summer, and let's see what it is. It's, to my knowledge, what I've found is relatively new since COVID has started. Some affluent parents in some other states started putting these things together. And I don't know. I don't know what I understood. They flew in here this summer and talked to a couple representatives. I wasn't aware of that. Don't know. But anyway, let's take our time. Let's do that. We owe it to the kids of the state. We owe it to the parents, like I said, to put something up like this with little to no oversight. And I think, let's do this right. I beg of you, let's do the study. Let's come back. We can separate these bills and do it right. So that's my concern. I hope you'll see it with me. Like I said, most of our kids, they don't necessarily have somebody to advocate for them. We're it. So I ask you today, as a delegation, let's do the right thing. Thank you, Mr. Speaker.
Is there debate on the bill? If not, gentleman number 27, Doug Ellington, to close debate on the bill.
I'd like to. Guys, the sky is falling, my Lord. It sounds like the whole world's going to stop with micropods and learning pods and micro schools. All these other states that have these, I don't think I've heard anything in the news about that the end of the days of the earth is ending right here. The goal of this is to educate our kids. There's different ways you educate kids. We have a public school system. We have private schools, parochial schools, home schools. We have different organizations that do different things. People can seek out whatever way they'd like to get educated. The bottom line is to be able to educate our kids. That's what our obligation is to do in this state. And alternatives may be good. Not everyone fits the same model, nor are people happy with the choices they have. This is just another way to give a choice for something that is already technically in code. This is free association of these parents to get together in groups to self or group educate their children. These mirror the same elements in code for homeschooling already. It does add the composite scores that they can do, or they can submit from these micro schools or these pods. Think about this. The parents usually have more hands-on involvement with their kids in these situations. These kids are going to be getting more one-on-one instruction than what they're seeing in our public schools. These kids usually do a lot better in the long run. Not every kid. There are exceptions to everything. Some kids are going to fall through the cracks. Some kids fall through the cracks in our public school system. We've done a bunch of things to try to fix it, but it still happens. We had to put cameras in the school to protect